On the Sixth Amendment, as you know, they're after lawyers all over the place. It used to be that lawyers were relatively immune from a lot of the aspects of criminal defense. They couldn't be disqualified readily. They didn't freeze the assets of your clients, so you couldn't be paid. Now they freeze RICO assets, as you know. There's no free counsel to indigents after the direct appeal is over. Under the Sixth Amendment, we have anonymous juries. I'll never forget during the Nicky Barnes case, the second Nicky Barnes case, one of the jurors was known as Juror 318, came to be questioned, and Frank Lopez turned to me and says, "Does 318, is that a Jewish name?" But that's the thing, you have the anonymous juries now, you don't know who you're getting unless you can see it on their faces or the color of their skin. One district court judge in Washington, D.C. decided that he would carry that one step further, and he excluded the public from the selection of jurors, anonymous jurors. Well, when that was overruled by the District of Columbia Circuit, he then bought masks out of the auxiliary fund of the district court, and the jurors would wear masks in the jury box. That was overruled by the District of Columbia Circuit. So finally, he got money again from the auxiliary fund, and over a weekend built Venetian blinds in front of the jury box so they could hide the faces of the jurors. That too was overruled. But maybe he sees the handwriting on the wall, and maybe in the future we'll have masks or public excluded from jury selection or Venetian blinds in front of the jury box. Rule 11, of course, is a disastrous rule. The ABA is trying to modify it, at least somewhat, provide safe harbor. But as one who has been fined $125,000 in North Carolina, I can attest to the fact that it's a very effective stimulant to avoiding federal civil rights litigation. It's been used primarily against civil rights lawyers. The Director General, Director Counsel of the NAACP Legal Defense Fund was fined $40,000. The leading civil rights lawyer in Tennessee, $45,000. The Christic Institute, $1 million, which put it out of business in Florida. Rule 11 is a horrible outgrowth. It's not even a congressional act, as you know. It's a rule of the district court, which is formulated by the courts themselves and not by the Congress. And it is a disaster. I had a very lucky experience just recently. I was Rule 11 with a censure by a judge by the name of Gattell, federal judge in the Southern District of New York. And it was overturned by a three-judge panel of the Second Circuit, indicating in their opinion that the judge was animated by a prejudice against me personally, but the court thought against all activist lawyers in general. That's a rare win in this business, but Rule 11 is a disaster. They're trying to modify it now. They do have a safe harbor provision, 21 days, to alter what you may have put in pleadings, but once you sign those pleadings, you're open for Rule 11. We have many other aspects of lawyers, as you know. Contempt, disqualification. Oscar Goodman is one good example of the contempt process out west. We have disqualification. I was excluded from representing Sheikh Omar Rahman on the grounds there was some alleged conflict of interest. Bruce Cutler was disqualified from John Gotti's case along with Gerald Shargell. And when they tried to employ James LaRosa to take over, the government put LaRosa's name on the witness list. They were going to call, of course they never called him, but he was then excluded from representing Gotti. So Gotti had to reach down in Florida and pull up the aged Albert Krieger up to New York. I think he was here yesterday, so age has not disqualified him from making that trip. But in any event, he did not have the lawyers that he wanted. This is a very general practice now. We have more disqualifications in New York than I can ever remember happening before. Just 2 days ago, the case of Lynn Stewart was argued in our appellate division. She was ordered to testify to a grand jury on funds received for representing clients. She refused. She was indicted under a felony statute, failure to cooperate with the grand jury, which would have meant her license, because we have the archaic rule here that any felony conviction, even if unrelated to the law, vehicular homicide, for example, is automatic disbarment in the state of New York. A state judge threw it out, but the people are prosecuting still, and the appeal was argued just 2 days ago in the appellate division first department. So there are many, many aspects of what they're doing to lawyers, what they're trying to do to lawyers. Gerald Lefcourt is testing the provision you have to disclose certain funds and where your funds came from to the government, and so on. You're all familiar with these, but the objective is to cut the lawyers down. This all started in 1735 with the case of Peter Zenger, John Peter Zenger, the printer, when his 2 lawyers were disqualified, disbarred on the eve of trial, 2 New York lawyers. And that required Andrew Hamilton to come up from Philadelphia in order to be the attorney for Zenger. That's where the term Philadelphia lawyer first materialized, when he came up on a barge from Philadelphia, successfully defended Zenger, and then returned to Philadelphia. Under the Seventh Amendment doesn't really pertain much to us. It has to do, as you know, with civil trials rather than criminal trials. The Eighth Amendment does, of course. Now we have mandatory life imprisonment for cocaine possession by a first offender. We have preventive detention under the so-called Bail Reform Act of 1984, one of Reagan's little beauties that he left behind. We have draconian sentences and draconian prisons like Marion and now the new ones that are floating around, Florence, Mariana, and so forth. Only one judge has had the courage to say the Eighth Amendment should forbid executions in this country. Unfortunately, he said it just as he was leaving the bench, and that was Harry Blackmun. But the Eighth Amendment, I think, is largely a thing of the past. I won't go into the 14th, 13th, 14th, and 15th, because essentially that's on the civil side. That's on the side of affirmative action and so on, which is not really the function of most lawyers that are here. But what has happened, the attacks on the Bill of Rights, whoever wrote the title here said the incredible shrinking Bill of Rights, but the attack on the Bill of Rights is an ongoing occurrence. Those who are in power don't want it, or don't want to expand it, want to shrink it as much as they can in order to keep their ship afloat. And they think they can keep that ship afloat mainly by destroying the power of people to resist that type of oppression by resorting to these ancient amendments of 1791. In considering all of this some time ago, E.L. Doctorow was a speaker at Brandeis at their commencement. And Brandeis, which is named after a justice of the Supreme Court, rather well-favored justice of the Supreme Court, Brandeis decided that they would not reprint Doctorow's speech in the Alumni Bulletin. Now, it's not a First Amendment case because they're a private institution, but the spirit of the First Amendment is certainly violated by a refusal of a school named after Justice Brandeis to not print, as they always do, a commencement address in their Alumni Bulletin. Finally, The Nation magazine printed it, and then the trustees of Brandeis relented and finally allowed it to be printed in the Alumni magazine. But here's one of the reasons why they didn't want to print it. Because Dr. Owen, considering he was talking about the Bill of Rights, he was talking about social legislation that wasn't enacted, and if enacted was repealed or sidetracked. And he said this about our country. He said, "It's my view that in the last decade or so in this country, we have seen a national regression to the robber baronial thinking of the 19th century. This amounts to nothing less than a deconstruction of America, the dismantling of enlightened social legislation that had begun to bring equity over a half century to the lives of working people, to rectify some of the terrible imbalance of racial injustice, and give a fair shake to the outsiders, the underdogs, the newcomers. We may have, in fact, broken down as a social contract in our time, as if we were not supposed to be a just nation, but a confederacy of stupid, murderous gluttons, so that finally our country, the idea, the virtue, the truth of America, is in danger of becoming a grotesque." Now, Justice Douglas had prophesied this many years earlier, when he said our court is taking away the customary and time-honored rights, amenities, privileges, and immunities that come within the sweep of the blessings of liberty mentioned in the preamble to the Constitution. Many of the states, of course, are rejecting what the Supreme Court has done in many areas. For example, in the area of the exclusionary rule. Massachusetts happens to be one of those. Minnesota and New York have refused the good faith exception to recognize what is binding on the in the federal courts. Governor William Weld of Massachusetts, when there was danger of Roe v. Wade being upset by the Supreme Court, asked for legislative remedial action if that was to take place. I guess in the long run, what we have here is a perennial crisis in seeking some form of liberty. I guess it occurs in every country. Countries get old. They forget the origins of their birth. They forget the ideals that brought them into being in the first place. And they become a grotesque, as E.L. Doctorow stated. And I think it's the role of lawyers, as much as possible, because they sit in those courts, they watch the grinding of the courts on human beings, they have a superb knowledge of what goes on, and I guess one of their responsibilities should be to fight it every inch of the way, not just to fight it because it might mean more money in the pocketbook, but because it's the right thing to do, and that lawyers can play a real role, not as chameleons on a television screen in Los Angeles, but in the courts of this country, in fighting oppression wherever it rears its head on the road that we travel. I've spent a lot of my life trying to do that. Sometimes I fail, sometimes I succeed. But I always tried to justify it in some way by having some philosophical background to sort of make the hard times a little easier to take. Because there is a lot of pathos, a lot of tragedy, a lot of deaths and injury along the way.